Good evening, everyone. We're gonna call the November 12th CAC meeting to order at 6 p.m. We'll go ahead and go around the room and introduce ourselves. I'm Lorena Barrera with the 3rd District.
Nancy Pemberton, 5th District.
Malden, IOLERO Director. Sheriff Eddie Ingram.
Frank Kidder, Lieutenant with the Sheriff's Office.
Robin Jers, District 1.
Alberto Oteo at large.
Michael Miller, District 4.
John Azevedo, District 4.
Casey Jones, District 2. Nathan Solomon, District 1.
Trevor Ward, District 3.
Imelda Martínez, Distrito 5.
Lisette Camacho with IOLERO.
Thank you. And it's awesome to see that all of the CAC is here today again, so thank you. Let's hope we can keep this up. We'll move on to item 2. Sonoma County Sheriff Eddie Ingram to speak on the censuring resolution adopted by the CAC at the October 8th. 2025 regular meeting. And because sometimes I talk a lot, I just wrote down what I wanted to say to introduce this item. I wanted to start by apologizing to everyone for not considering inviting Sheriff Ingram to our meeting in October. I keep talking about trying to have efficient meetings and failed to consider a different approach last month when we discussed the censure resolution. So I just wanted to say that, and I wanted to thank Sheriff Ingram for understanding and for accepting my invitation to be here tonight to discuss this resolution. And then just for future consideration, please know that you're more than welcome to attend any of our meetings. You don't need an official invite. And if you have any anything that you want to say or just be present, you're very well respected and you're more than welcome to come at any time. But also Lieutenant Kidder does a great job, so know that as well. So I don't know if you'd like to start off and if you had anything that you wanted to say before, or if you just prefer that we take questions from the CAC. And just so you all know, once we approve things as a body, normally Lizette sends things to the sheriff's office, and in this case, because of the whole topic, I sent everything directly to Sheriff Ingram the following day, and we kind of took it from there. So that's how he received the resolution that we discussed in October.
So I guess start out with a prepared statement and then. Thank you, Chair and members of the CAC. I understand the committee intends to affirm its censure decision this evening. Before that occurs, I want to make one request that we return to dialogue. Throughout my tenure as sheriff, I've never refused to meet with this committee on any issue. The CAC's goal is to serve as a bridge between the sheriff's office, IOLERO, and the community. But in this matter, there was no bridge, no discussion, no fact clarification, no opportunity to respond before judgment. That lack of conversation, among other things, are part of what has contributed to the mistrust of the CAC and IOLERO by members of my office. To move forward, we need a shared understanding of the governing legal framework, particularly Measure B, and what followed after its passage. While 64% of voters approved Measure B in 2020, legal issues arose immediately regarding the county's obligation to meet and confer with employee associations before placing it on the ballot. In 2021, FERB ruled the county unlawfully enforced portions of Measure B as to represented employees. To remedy this, in June of 2022, the county and the Deputy Sheriff's Association negotiated a letter of agreement. That LOA took precedence where it conflicted with the ordinance. Days later, the Court of Appeal affirmed that the county was required to bargain the foreseeable effect of Measure B before placing it on the ballot. By that time, the LOA structure was already in place. In April of 2023, the first amended LOA was negotiated, and that remains a controlling document today. The LOA clarifies IOLERO's authority to review case files, conduct audits, and independent investigations, but it does not authorize IOLERO to conduct compelled interviews, neither does Measure B. FERB reaffirmed this in 2023, ordering the county to cease enforcing conflicting portions of Measure B, and in subsequent Superior Court matters, the court held that the LOA supersedes the ordinance whenever conflict exists. That was part of the whistleblower case, and that portion is up to, the appeals court. Turning to the Peleas Chavez matter, there was no instance in which the sheriff's office impeded IOLERO. Subpoenas were served. When deputies indicated they would assert their Fifth Amendment rights after consulting with their counsel, they believed they could inform the IOLERO investigator of their intent in not attend interviews. I directed them to attend those interviews as required by the subpoena. I cannot legally compel an individual to waive their constitutional rights for IOLERO. When it comes to providing the IOLERO investigator with records in a timely fashion, records were provided as they became available in accordance with the ordinance, the LOA, and our operational agreement with IOLERO. The investigator may believe we withheld records from them, but the fact is, certain items required redaction by law because IOLERO does not have CLETS access, which is required to view some information. Additionally, as there were a large amount of information in this case, we could not upload it to AIM, which is our normal way of sharing information with IOLERO. We had to come up with a different way to share that information, which is updated through evidence.com. Determining what was best for that process took time. The sheriff's office did not necessarily withhold or delay transmitting any information to IOLERO maliciously as is being suggested by this committee. Regarding the concern that no deputy interviews were conducted, resulting in what is being characterized as an incomplete investigation, a violation of the checklist in our agreement with IOLERO, that conclusion is based on applying the standard of an internal affairs investigation. If this case was an internal affairs investigation, you would be correct. However, that is not the appropriate standard for evaluating this matter. The Peleas Chavez case was handled as an administrative review, not as an internal affairs investigation. Administrative reviews are designed to evaluate tactics, training, decision-making, and policy adherence, not to investigate misconduct. If an administrative review, evidence of potential misconduct is identified and a separate internal affairs investigation is initiated and interviews would have taken place. That is precisely the process that followed after the David Ward case involving Deputy Blount and several other cases. The belief that it was an incomplete investigation is a misinterpretation of our policy and how the Peleas Chavez case was handled. Therefore, evaluating the completeness of this administrative review using internal affairs standards is not accurate or proper. It is a correct standard for an administrative review. The review is properly completed. Now to the central issue, why I cannot issue a LIBOR recognition on IOLERO's behalf. There is no provision in Measure P or the LOA that grants that authority. And California case law makes it clear that any attempt to compel interviews and oversight investigations must be negotiated and must respect employee due process rights. We see this in Los Angeles, where the Board of Supervisors adopted their oversight ordinance in January 2020, granting subpoena power to its Civilian Oversight Commission and Inspector General. The Association of Los Angeles Deputy Sheriffs challenged the ordinance, arguing the county implemented it without first negotiating the impacts on represented employees as required by the Myers-Brown Act. The Los Angeles County Employee Relations Commission, which is their version of PERB, agreed, ruling the county violated its duty to meet and confer. The Superior Court issued a preliminary injunction finding that compelling deputies to answer questions for oversight triggered bargaining obligations. The California Court of Appeal affirmed that ruling. The takeaway is simple and legally binding. A county cannot compel employee statements for civilian oversight without first negotiating the procedure to meet and confer. If it does, it violates state labor law. This is why San Francisco is the only county in the state of California that can issue compelled statements in the oversight investigations, and Sonoma County cannot. San Francisco negotiated that authority. Sonoma County has not. So the issue is not whether I want to compel statements. The issue is whether I'm legally allowed to. Under current law and the controlling LOA, I am not. If we had attempted to do so, we would risk the same legal violations that Los Angeles was found to have committed. I'm not here to argue against oversight. I'm here to support oversight that is lawful, fair, and trusted. That requires clear rules and shared facts. I'll close by saying this. This body is imposing a sanction on me not for defiance or obstruction, but for adhering to controlling case law, court rulings, and negotiated agreements that define what is lawful in Sonoma County. I follow the same legal standard that every other sheriff in California is bound to follow. Punishing lawful compliance does not strengthen oversight, it weakens it. I remain committed to open communication, lawful transparency, and collaboration, but I cannot and will not violate law, negotiated agreements between the county and its labor groups, or the Constitution to satisfy political expectations.
Thank you, Sheriff. And now, you're okay with taking questions,
I
right?
am.
Are there any CAC members who want to start off?
I have a question. Why is it that your administrative review process does not include interviews with the people who are, or who have been, whose conduct is being looked at?
Because as I said, administrative reviews are things we do on a multitude of cases. An administrative review can be anything that I choose to review. And if I find policy violations in there, they separate it out because administrative reviews are not investigations. No one in an administrative review is accused of violating policy. No one in an administrative review is accused of violating the law. If during the administrative review, we would feel that there is a policy violation, then we pull it out and have a separate case. We did that in the David Ward case. We're actually doing that, and we're actually doing an administrative review on the case where the deputy murdered his former girlfriend and himself. And in that administrative review, we determined that anyone, if there is suspicion that anyone in that is in that administrative review involved in it has violated our policy, then we do a separate case because a lot of people can be involved in an administrative review. That's the way that our policy reads, and that's the way that we've always done it. If you go back and you look at David Ward and any of these other cases where we actually terminated or disciplined or fired employees, the administrative review comes first, the investigation comes second, because there are people in there that may not violate policy.
So,
So you may wish it to be another way, but this is the way.
I'm not,
it is.
I do wish it to be another way, but that's okay. I'm not arguing with you about that right now. And I'm not arguing with you. I'm just trying to understand. It seems to me that part of looking at policy review, looking at whether policies have been complied with, is trying to figure out what was going on in this instance with the person who committed the killing. What their sense was, what steps they might take to comply with policy, what steps they didn't take to comply with policy, whether they considered policy. And so I guess two things. One is I'm not sure I understand how you can complete the review without that. But the other part is, I guess, in conversations between IOLERO staff and the sheriff's department, was there any question about the sheriff IA conducting those interviews that IOLERO wanted, and asking the questions that IOLERO wanted asked?
In every officer involved shooting, we do an administrative review. And based on the administrative review, we then take action if we believe that there is possibly a policy violation. That's the way that we conduct administrative reviews. Here's a perfect example of when we probably wouldn't do an interview. Do we all remember the Todd Road shooting? The Todd Road shooting where the guy shot at all the deputies with the
Oh,
AK.
Yeah.
Why would I interview deputies in that? They showed up and they were shot at. And they fired back. What purpose would I do that? They showed up and they were fired upon by someone with an AK-47. There's no reason for me to do the interviews in that case. So an administrative review is what we look to inform whether we should do interviews or further investigations or internal affairs if someone is determined to have violated, we believe someone has violated policy. So that is why we do it. That, among other things, is why we do it the way we do. And as I said, administrative reviews are not necessarily always for in custody deaths or officer involved shootings or what have you. If we have, for example, a SWAT call out and it just didn't sit right for whatever reason, we could do an administrative review on that. And that is another case where Manga Circle, this happened in 2014, 2012, somewhere around there. We did an administrative review on that. The person's held up in their home. We did a SWAT call out. They ultimately ended up committing suicide in their home. We did a administrative review on that. Based on the administrative review, we felt there may have been policy violations. We did internal affairs investigations outside of the administrative review, and I believe in that case, 2 or 3 people were found to be in violation of policy.
If you suspected criminal activity on the part of a deputy, would you do the criminal IA investigation side first? Or would you do the administrative review first?
The criminal always comes first.
Always first. And so, once you get to administrative, essentially what you're saying is you've moved, you're not, this person's probably not gonna get charged. You don't suspect they committed a crime or violated policy, and therefore it's going to that next phase of
Well,
administrative review?
I can't say
That-
I can't say whether they would be charged or not. So in a case where the criminal has occurred and it goes to the district attorney's office, if the
Right.
district attorney's office charged that person with a crime, we would, in our administrative review, then go to the policy where they are suspected to have committed a crime, and then we would do internal affairs out of that portion of it and then interview them.
Sorry, I didn't mean to step on your question. I just wanted to follow up. Yeah.
Well, I guess the second part of my question is whether you had discussion with IOLERO staff about conducting the interviews that in their bed.
For me conducting interviews in their step, I can't conduct administrative interviews on IOLERO's behalf. There's nothing in Measure P that allows me to do that, and I can't compel statements for someone, for an investigation that is not mine. I can compel for my investigation, I can't compel statements for another person's investigation. So if IOLERO is doing the investigation on my behalf, which we've had people do before, for example, if anyone in the command staff is accused of
In
violating
the web.
command staff.
Oh, it's command.
So if anyone in my command staff is accused of violating policy or there's an internal affairs case, in that case, we hire an outside firm to do that investigation, and I delegate my authority for them to do those investigations, but it's for my investigation, for me to impose discipline. IOLERO can impose discipline, so it's not my investigation, it's their investigation.
Any other question?
What triggers an internal affairs investigation
In general, or
in general?
various things. I mean, we have 3 different types of internal affairs investigation. We have internal affairs investigation, we have policy and procedure violations, and we have citizen complaints. They're all a category of internal affairs investigation. Citizen complaint is essentially what it sounds like. Someone from a citizen filed a complaint, whether through IOLERO or whether through our office. That would trigger an investigation. Policy and procedure is something that is initiated typically by a supervisor or a manager. So if a supervisor says it believes the deputy did something wrong, they report that up and go up to Brent to decide whether their supervisor or another manager is going to conduct that investigation, or whether someone in internal affairs is going to conduct that investigation. And internal affairs investigations are something that is generally started at the management level or at my level. So they're all internal affairs investigations, they're just different categories.
Was there a complaint about the Playas Chavez shooting?
No,
Their civil lawsuit being considered such?
no.
So you used the example of somebody, shooting a assault rifle at officers and, but that's not what you had here, right? You had a man with a rock, right? In a long course of conduct prior to that, and the issue was it a proper use of force to shoot the center body mass when faced with the possibility that a rock would be thrown, right? So that there's no desire on your part to use your authority to order the involved deputy to respond to questions about the nature of the threat that he was facing, which is kind of the centerpiece of the determination.
The deputy did respond to questions during the criminal investigation. That was what those statements that the deputy made, whether the decisions that the district attorney made to decide whether there was criminality in this case. The district attorney decided that there was no criminality in this case, did not charge. Had the district attorney charged, then I would have a law violation, which is a possible law violation, which is a violation of policy. And then we would have conducted an internal affairs investigation based on that, but that's not what occurred.
So your analysis of whether there was a policy violation, in your view, is just side by side with, did somebody else determine that it was appropriate to charge a crime? And there's no independent judgment for you or your organization
Well,
to
there
make?
there is an independent judgment. That was my independent judgment. Our policy mirrors 835A of the penal code, which talks about the use of force and when it's reasonable and practical. The DA uses that same element to determine whether they should file charges. So based on the district attorney determining that there was no violation of 835A, which our policy mirrors when it comes to use of force, then that's the judgment that I used. I'm not going to question the district attorney. If the district attorney charged, then we would open an internal affairs investigation, and most likely they would have been sustained because the district attorney said that it was probable that the district attorney determined there was probable cause that they violated the law. For our standard, it's not probable cause. It's lower than that.
I agree, and that's why I think there's actually space for you to look at the policy violation differently than just what did the DA do? And that's why I asked that question.
The question I would ask you is, what would I elicit from an interview with that deputy that I did not get from the criminal investigation? Because when you talk about how a person evaluated policy or when they did policy, that's easy to say is sitting in the seats that you're sitting in and not having been a law enforcement officer. Because I'll tell you, having been in multiple situations as a law enforcement officer, there's no policy running through our head. Policy 1, 2, 3 says X, Y, Z, so I would respond in this way. That's not how officers or deputies in the street evaluate policy. Now, if you're sitting down and you're writing a criminal report that's cold, and you're saying, okay, this is a child abuse report, what does policy say that I have to do in order to make a complete child abuse report? Who do I have to report to? What do I have to do? Then yeah, but when you're out in the street and you're faced with the situation, there's really no evaluation policy. That what they said is, I perceived a threat. That's what they said in the interview, and I neutralized the threat. As far as shooting to center mass, that's where we always shoot. We shoot to stop the threat.
Right, but the central issue, though, for the organization, as I understand it, Sheriff, is not what does the deputy tell you he perceived. It's, do you make a determination that that was a reasonable response to the objective picture that you glean by your investigation?
Sure. When you speak, can you just speak a little?
And based on the information that I saw, which is based on what the DA saw, which is based on the interviews that were conducted, I believe that that was a reasonable response.
Okay, and that I understand, that provides me personally some clarity, which is that you looked at questions and answers that were asked of this individual in a separate investigation, and you made your own determination rather than just whatever the DA does, I do.
Well,
Because they are different standards, and you have a different set of interests than the prosecutor for a county.
well, I would think that would probably go without saying because I signed off on the administrative review. So I review every administrative review that comes through. So if I sign off on an administrative review, it's based on my determination. Just like in other internal affairs cases, there have been cases where an internal affairs cases have come through, and the internal affairs investigator has exonerated them, and I've read it and have not exonerated them. So I evaluate every internal affairs case or administrative review that comes across my desk. And sometimes I agree with the investigators, sometimes I don't. Sometimes I send them back for additional information. 2 weeks ago, I sent it back and had an additional policy violation added. So every case that I get, I evaluate.
Can I just follow up? I mean, you said nobody thinks about policy when they're in that situation, and I understand nobody's going, oh, policy, what is policy? But there was a decision on the ground that one person would be to have a taser and one person would have lethal force, correct?
Right.
And that wasn't required by criminal law, right?
No,
Right, so there is some issues in your administrative review that are not addressed in the criminal context, because the criminal law and your policies are not, there may be overlap, but they're not completely.
I don't understand the statement.
Your deputies had to know, were required, somebody has to be a taser person and somebody has to be a lethal enforcement. That's not part of your
That's not
policy.
part of my policy, no.
Is
Yeah, but
any de-escalation part of your policy?
The escalation is, but whether someone has, having a taser and then having lethal cover is not part of de-escalation, that's a sound tactic.
I'm asking you a different question, because you said that the taser was not
Okay.
part of it, was not an issue,
There's-
so
but
I'm
I-
asking you
but I said
about
what's the
de-escalation.
But I said, what's the requirement to have a taser and lethal cover is not a requirement within policy. What I see that is two deputies who are out and making a decision and trying to get a tactical advantage or come to a tactical closure. And not use lethal force.
Okay, but de-escalation is a part of your policy,
It is,
and it's not part of criminal law. They don't have to
It is.
de-escalate,
it is.
they have to de-escalate?
They have to make an effort to do that, yeah, that's part of the law.
The new A35A.
Say that again?
It's the
new
new
A35A.
A35A.
Oh, okay. And when I understand what Casey's question is about the standard of your review, probable cause versus
Right.
whatever your standard is. Is there a standard of intent or negligence that is different in criminal law than in your policies?
Intent or negligence and how so?
Like negligently not completely. Let me give you an example. I'm in a situation, I've done some things for de-escalation, and then I don't think of XYZ that I could have done.
At hindsight 2020 and the law and case law really pull that out. There are many cases that talk about the use of force by a reasonable officer standard, which means 2020 hindsight isn't something that's brought in. Could this have happened? Yes, all those things could have possibly happened in another timeline of possibility. True. However, that's not what occurred in this case. Could Mr. Polias Chavez have stopped? He could have.
Okay,
Could Deputy Dietrich have missed? Could have. There's all
could
the.
he have stepped back to be farther away from the rock,
Or did he have to step forward?
or
I
did he
mean,
have to step
'cause he-
forward?
he-
There's
closed
nothing in
space.
law. There's
Right.
nothing in law that requires a law enforcement officer to retreat to perform their duties. It says that we do not have to retreat to perform our duties. De-escalation is in there, and I think chasing someone for the better part of 30 to 45 minutes, calling and asking, telling them to stop. Yes, I understand there were language barriers, that is understanding, but we also can't airdrop an interpreter into the field to do that. We can't airdrop someone from the mobile support team in to do mental health assessments. That's not the reality in which we live in. So again, it's easy to sit back academically and read these things and say could have, should have, this could have happened, but that wasn't the situation that they were faced with. And based on the law, which is what our policy is close to, it was reasonable under the law. Now, some may agree, some may disagree. We could have had a very different DA who could have made a very different determination, but that's what the DA determined.
Is part of your administrative review discussing Dietrich closing space? Or not?
Sorry.
Like part of your administrative review of that incident? Did you cover Dietrich closing space between him and Peleas Chavez, or is that considered outside the scope of the administrative review?
We didn't really look at that. We looked at the reasonableness of
Okay.
and whether we should open an internal affairs based on that.
Gotcha.
And again,
Not
there's nothing in law that says that, he has to retreat.
Right, frankly, closing space likely would not have been any sort of policy violation anyway. There's nothing to say that you can't close the distance. in certain
Right.
Aspects.
But I mean, you're also creating the very risk that he's gonna cite in shooting him, right? Because he's closing space and then there's a rock. So now he's saying, I'm so close, the rock is now a deadly weapon, so I must shoot.
So now we're having a tactical discussion as
Right.
opposed to a policy discussion. And
There's no overlap?
no, there can be some overlap. So now we're, my understanding of your censure or sanction or whatever it is, are several things. Did we conduct a thorough investigation? It wasn't an investigation, it was an administrative review.
Yep.
I didn't order deputies to talk. I can't legally do that. I impeded the investigations. The deputy said, I served the deputies with subpoenas. They said they weren't gonna go. I told them they needed to go.
That was new information to me actually tonight.
So
To be
I
honest.
think Director Holden even mentioned that.
Yeah.
That we served with subpoenas.
No, to your point, we're pretty far afield from the topic. But since we had you here, I think we had to try at least pass.
Yeah, I can appreciate that. Some may disagree. But these are the way that we have done these. Well, they've served us pretty well. We've had 3 deputies charged. They've pulled on under these same policies. Where they ended up in court really weren't our issue. They were charged and terminated based on the same way that we've done things. We've had deputies terminated, not necessarily charged, but terminated based on doing things this way. And really we have to look at what's the vast majority of these sort of cases that we come across. You know, this body was created out of Randy Lopez shooting. A lot of law has changed since then, a lot of policy has changed since then. So, you know, we're not looking through the same lens as we were back then. It's a different lens. And, you know, 45A was something that really changed how law enforcement affects force, not just at the sheriff's office, but statewide. And that's the lens that our policy is geared toward. And that is how we evaluate if we're going to conduct further investigations. In some cases they do, some cases we don't.
Have you invoked Libarger for any of your sheriff's deputies since you started?
I don't think we've had it. Yeah, we have every interview for Libarger.
Okay.
Yeah,
So it's just,
every case that internal affairs, every investigation that internal affairs conducts, there is a Libarger admonition.
So Sheriff, going forward, obviously there's a disagreement about your authority to give a Libarger admonition and compel your people to.
I don't know if I don't believe there's a disagreement.
I think
it's pretty clear in the law.
I think there is a disagreement in this room. I think there is a disagreement in this room.
it's in the courts,
Are
right?
you saying that the case in Los Angeles, it doesn't mirror this case?
Well, since you asked, I would say it does not mirror this case. The distinction in Los Angeles is that Sheriff Luna said, I intend to issue Libarger advisements to sheriff's deputies and require them to talk. And then that was what triggered them going into being conferred. And so I think the only thing that is different about the Los Angeles situation is that Sheriff Luna said, I will make the order. Here in Sonoma County, our sheriff says, I will not make the order. But once you get past that point, then we go to meet and confer. We could get to meet and confer in Sonoma County if the sheriff were willing to make that order. Because he's not, we can't.
So
let me.
Go ahead.
Yeah, let him respond.
So what you just said is that we don't disagree whether I can. We know that I cannot, but then do is force the deputy sheriff to be confer. So we're not disagreeing.
No, respectfully, we are.
How so? If I ordered the deputies to interview, what would happen?
Sheriff, I respectfully believe that if you said today, I'm going to order sheriff's deputies pursuant to Libarger to answer questions at IOLERO or else is disciplinary action with the sheriff's office. Then our next step would be that you and I would work with human resources to see if the Deputy Sheriff's Association wanted to meet and confer, presumably they would. And then we do that process, and when we're done with it, then we'll be able to start ordering people to answer questions at IOLERO, which is exactly what's happening in some of this.
So why don't you engage the county to, or why do I have to pay for that? Because I
You know,
do.
I have.
So
I would
that's my point.
Well, respectfully, let me answer that question. I mean, that's a great question. And it's one you and I don't think have talked about. If part of the question is cost, I would be happy to talk to the county about how we allocate that cost. I'm open to having that conversation and it's what we've had yet. I have been advised by the county, and I think they're right, that we can't get into the room to meet and confer it unless your sheriff are willing to open the door and say, yes, I will need that order, let's meet and confer about it.
Why?
And I respect that that's your authority, but I do think respectfully that the place we're in now is that you are making a decision not to use that authority, and that is within your power, I think. And so then that leads us in a place where we don't have to compel them to use it out.
So I think what you're doing is talking around the facts. The fact is, if I order deputies, it will force me to confer.
Yes.
Just like, that's what I said. If I did that, it would force me to confer, just like it did just like it did in Los Angeles.
Yes.
Why would I do that?
That's a desirable outcome. This body thinks that's a desirable outcome. And we think that the voters think that that's a desirable outcome. That's why.
Well,
Let me finish, let me finish. So, we think that based on what the voters have done, that their clear intention is that IOLERO have the ability to investigate potential wrongdoing by sheriff's deputies and sheriff personnel. We think that that is self-evident. People could pick a bone with, you know, what kind, and are picking a bone right now in other litigation as to what is the nature of the investigation. But we think that, that the intent, and this body certainly thinks that the intent is that John and his staff should be able to ask your deputies questions and have them be compelled to answer truthfully. That's what we think. And so the only way, and I think you may well be right, Sheriff, the only way that that happens is if the county goes through the process of ordering, dealing with the appropriate labor procedures that need to be done to get across the finish line so that his people can ask questions and get answers, and we're not there.
Well, respectfully, let me give you a bit of history, not just with the sheriff's office, but with county employees as a whole. County employees have had their medical care taken from them, retired by the county. Retired employees have not received a COLA. This bargaining group and the other bargaining group have gone years without raises commensurate with the job that they do. When the board went to put this on the ballot, the both bargaining units asked the board to meet and confer. They chose not to, and they put it on the ballot anyway. Had they done that, these things would have been resolved, but they didn't do it. After the deputies had to take them to court to get in the room to bargain, to get what we have. So they had the first letters of agreement. Those first letters of agreement weren't in place a year before they were in negotiating for a second letter of agreement. That's why the county can't negotiate with them now without me doing something, is because twice within the span of about a year and a half, they negotiated these letters of agreement. It's not my issue that the person negotiating on behalf of IOLERO did not see this. It's not mine, not my problem to fix. They should have known, whether it be Garrett Byers in the beginning or whether it be John towards the end. They should have seen this.
But Sheriff,
They should have seen this. It's not my issue to fix.
Right.
They did not treat their employees fairly, and I'm not gonna be another person from the county who treats their employees unfairly. I'm not going to do it, because that's what happened from beginning to end in this process. They did not treat employees fairly.
I hear you saying that because, so my takeaway from what I just heard you say is that because other people screwed up other negotiations historically, that you are not willing to work with John and the county to get the kind of investigations where deputies are going to be required to answer questions.
Deputies are required to answer questions to me.
Right, but the voters required, their clear intent is to have IOLERO have that ability to get questions answered, just like you can get questions
The
answered.
voters' clear intent in Prop 187 was for people who were in this country legally not to get medical care. But it was wrong.
Well,
The intent of the voters in Proposition 8 was for people of the same sex not to get married, but they were wrong. So there are a lot of things that voters do that are wrong. And it was wrong to place this on the ballot without meeting and conferring with people. And I'm not going to add on to that. Voters sometimes do things that are wrong and the process is wrong. That happens all the time.
so.
It's happening today.
So you're not willing then, is what I'm hearing, to work with the appropriate people to get the kind of investigation that the voters have asked for.
What I'm saying is that this is not my issue. It is not. It is not my issue.
You can make it your issue.
Why would I make it my issue? If this was to be my issue, then the writers of Measure P would have sat down with the sheriff at the time and worked something out, but they did not.
Yeah, but
The voters at the time, if they wanted to make it a sheriff's issue, then they could have talked to the sheriff. If they wanted to bring the deputies in, they could have. The deputies asked and begged for them to, and they did not. They did not. It is not my issue to clean up someone's mess. I'm not cleaning up someone else's backyard. And if you want to talk about the things in cooperation, there are many things that I ask IOLERO for, and I get nothing. Many things. I ask for things to be done this way. I've asked for things to be done that way. We asked for IOLERO to adhere to our operational agreement where their investigators will meet with my investigators prior to us doing an investigation for IOLERO. They refuse. They don't do it. It says it in our operational agreement. They don't do it. And the answer is, well, we don't want to color the investigation. Well, we want to do a complete investigation as you keep asking us to do. So let's sit down and talk about what we're going to investigate so we get a complete investigation. We don't want to do that. They'd much rather my investigators do the investigation and then send it back as incomplete.
I would like to hear more about that, but I feel like we should get back to the topic kind of at hand. I appreciate you coming here and speaking freely with us. I mean, this is actually really helpful. I think there's obviously like difference of opinion when it comes to the law. I'm not a lawyer, so I'm not gonna speak to any of that, but I will let other people speak to that. I had another question though for you, kind of like a basic question about when you're being advised legally, who does that for you? Is it county council? Is it DSA lawyers? Is it someone else? Like how does that work?
It depends. So if it's something that's a conflict between IOLERO and my office, then we each have outside counsel.
Okay. Otherwise it would be county
Otherwise,
council?
it would be county counsel.
Gotcha.
So as long as there's not a conflict between, and that's in general, as long as there's not a conflict between two county departments, it's county council. If there's a conflict between two county departments, then we have outside counsel.
Okay, and I would say I don't want to speak for this body necessarily, but just from my own experience, and I'm a longstanding member. The Board of Supervisors messed up by not meeting and conferring. I think that is absolutely true statement. And I don't think there's a ton of disagreement about that. And I think Garrick also probably shouldn't have been negotiating LOAs as an interim director either. So there were mistakes made in this process. Over those years, especially, that we're all having to deal with. But I think at this point, we still need to look at how things exist and how we move forward. And I think that's really important. And that's kind of what we're talking about. So like when you come and say, it's not my problem to fix, it's not my thing, it feels obstructive, right? Like it feels like you're kind of putting up a wall. And that's exactly, I think, what leads us to the censure thing last meeting. I mean, that's kind of what got us there. And I feel like we've come full circle almost on that. Do you understand like our perspective on that?
I understand your perspective. Well, what I would say is that if you are going to censure me for following what I believe the law is, then that's what you do. If you want to censure me for not triggering me to confer, then you can censure me for not triggering me to confer. But, you know, what I want to say is that if you're going to censure me, then censure me for what I've done, not as to what you perceive that I've done. The reality is this. It is very easy for members of the CAC to sit here and say that the sheriff should do or negotiate with IOLERO and do these things. Well, I will tell you that on other things, I have tried to negotiate with IOLERO and I've gotten nothing, not one thing, not one. I've come to this very open. How do we fix incomplete reports? Let's do the completeness checklist. How do we fix this? Let's do that. You know, even now, there is a thought of doing an independent investigation on the Todd Road shooting, where the deputies were shot at first. For what purpose? What are we doing? Why? What I see and what my employees see is an agency that wants to tear my employees down and make it look like they do something wrong when they don't. Someone shot at them first. They showed up and were shot at. Bullets riddled Deputy Newbeer's car before he was even out of it. And we're gonna do an independent investigation on that.
Was someone struck by a vehicle?
They were struck by shrapnel, and one deputy was hit by a car.
Hit by
Yeah,
a deputy's car, right?
Yes.
Okay, so maybe the investigation is about that. I have no idea. I don't know anything
Yeah.
beyond what is in the papers on that. So I mean, it's like I'm vaguely recalling.
So my point is that there was always calls for the sheriff's office to negotiate and the sheriff's office to do this and the sheriff's office to do that. If we were working in true cooperation with each other, then when the sheriff's office asked for things, which I think are sometimes reasonable. For example, why are we investigating cases again that we've already investigated? Another example, we triggered an investigation based on the use of force, 2 uses of forces in the same case. One, we reviewed the use of force as we typically do, not all use of force go to IOLERO. We reviewed the use of force. We cleared the one use of force. The other one, we thought we had an issue with, so we conducted an internal affairs case. We finished that, we sent it over to the IOLERO and they said, we need to investigate this deputy here. Well, we already went through our normal review and we felt that deputy acted appropriately. We opened this case to investigate this deputy. Well, you need to do it or this case is gonna be considered incomplete. Where's the reasonableness in that? So when an office is not being reasonable with me in the treatment of my employees, why?
I mean, I would love to get a list from you guys, honestly, like of instances where you feel like you've asked something reasonable of IOLERO and they have just basically not responded or just ignored the request. I mean, I would love to hear that because to me, that's something that we should discuss and we should be open about it. You know. Yeah, I'll leave it at that, but I think it's important for all of us to like be honest with how this is going. And I mean, what do you like? I kind of want to hear from you. Like, what do you think is the way forward? From sitting right here, like when it comes to investigation, how do you see this playing out in your ideal world?
I think the county should ask the deputy sheriff if they want to meet me further about it. I don't think that I should be the one triggering it because I know what it's going to trigger. Why would I do something that would potentially violate someone's employee rights, knowing? Because that's what you are asking me to do. I know that this will trigger a labor complaint. I know it.
That's why you do the meet and confer though, right? So there is no complaint.
The deputies aren't going to meet and confer with me unless I trigger a complaint. If I went to the deputies and I said, let's meet and confer about me giving you live arbor for IOLERO, they say, no, we're not gonna do that. We negotiated 2 LOAs. It's not an agreement between you and I, it's an agreement between the county, IOLERO, and the deputy sheriff. It's not my agreement. It's an agreement for him. It's not my agreement. So what would happen is, so what you all are asking me to do is to do an event that would trigger a labor violation solely to get to meet and confer to resolve the issue that should have been resolved on the front end. I know it's going to trigger a labor violation. I know it. Why would I do that? The reason Sheriff Luna did it is because Sheriff Luna didn't know. He was a new sheriff who came from the police department and had no knowledge of it before that. And I know that because I've talked to Sheriff Luna about it. If Sheriff Lubin knew then what he knows now, he would never have done that. And I know it because he told me.
So, Sheriff, are you saying that, because that. When we had this kind of discussion on this resolution the last time, I kind of thought. That it was supposed to be the board of supervisors who initiate that process. And then and that it wasn't supposed to be you. And it sounds like there is kind of that loophole where that can happen, but it also sounds like anything that triggers the meet and confer process has to be initiated.
So the issue is that the board can't ask for a meet and confer because they've already met and conferred on this issue twice. And so if the board goes to meet and confer again for this issue, then it could be seen potentially as bad faith bargaining, because the only reason that the county wants to meet and confer is to put this in. But meeting and conferring is a negotiation. So the question now becomes, if you want this in, what do you want out? Because it's a negotiation. You just can't sit down and say, let's negotiate. You, deputy sheriff, you give IOLERO the right to interview you. Okay, negotiation over. That's not how negotiations work. If you want to negotiate, even if I do trigger meet and confer, even if I did, which I wouldn't because I know it's a labor violation, but it's a negotiation. So the county can't do it because they've already had 2 negotiations on this same issue in the span of 2.5 years. That's why the county won't do it. And the only way for someone to do it is to trigger a labor violation that the courts will force to meet and confer, which means that I would have to do it. Now, even if I did, as I said, it's a negotiation. So you have to ask yourselves, what in the LOA do you want out in order to get this? Because, as I said, a negotiation isn't just you get what you want and the deputy sheriffs get nothing.
I'm sorry, but I've got to jump in there.
Okay.
I think that's a dramatically incorrect explanation of the meet and confer process. So meet and confer is not a negotiation, where let's say a contract review, all decisions can be required. It's an opportunity for someone in management, like a sheriff, to say, I'm going to change the working conditions here. This is what they're going to look like. And then answer questions from me about what it's going to look like. If they have concerns, there's an opportunity for management to add additional details or provide additional guidance if management wants to. Management's not required to do that, and so pardon, I do want to hear from the sheriff, but just give me a minute. And in that process of meeting and conferring, it's not truly a negotiation, it's a conversation. So it's an opportunity to create clarity, create boundaries, see if there's some more understandings that need to be reached. The county doesn't have to give up anything in order to create a process of giving live arbiter advisements to deputy sheriffs when they come into dialogue and interview. They might ask for things, the county might choose to do things, but that's not necessarily required, nor is there anything special about the fact that letters of agreement have already been discussed a couple of times. If any member of any department in the county said, I want to start live bartering, my employees, we haven't done that in the past in this environment. They could go meet and confer with them and start doing that at any time, and the same is true of the sheriff's office. So in that regard, I do not believe that the board is prohibited from meeting and conferring this issue. It was very clear to me from the advice I've gotten and from what I've seen in other counties, cities where I've done this meeting and confer process, that the only thing we need is for the sheriff to help us by saying, I would like to start showing those waivers. Let's start by meeting and confirming. And I'd be happy to be a partner with the sheriff.
So if the sheriff had not needed to meet and confer, then why are we even having this conversation?
No, I
The
think
sheriff,
you are, sir.
the sheriff wasn't needed in the first LOA, the sheriff was not needed in the second LOA. The sheriff was no part of that, neither one, only to give advice and practical how things work within the sheriff's office. The sheriff was not involved in the first negotiation of the LOA, nor was the sheriff involved in the second negotiation of the LOA. So if the county could then negotiate, as Director Alden says, why am I here? The county can go and reach out, the HR can reach out to the Deputy Sheriff's Association and say, we want to meet and confer on this issue. The fact is, and the county has said as such, that they have negotiated this twice within a certain amount of year, and they are concerned that this being seen as an unfair negotiation, if they bring this back for an additional negotiation. If I'm wrong, then have the conversation with HR and the county can get involved with the negotiation with the DSA and SCLEA as they did before, because the sheriff was not involved in those negotiations. This is not a negotiation for me, for my for my employees working for me. It is not, it is a negotiation for him. If I wanted to change the deputy schedule, if I wanted to change their shift bid process, that would be something that I would be negotiating for. If I wanted to change how we do internal affairs investigations, that would be something that I would be negotiating for. But it is not for me. It is for IOLERO, which is a completely different department. The sheriff had no decision-making or no negotiations in placing this on the ballot. The sheriff at the time had no negotiation in the first letter of agreement. The sheriff at the time had no negotiation in the second letter of agreement. Because this is not an agreement between the sheriff and the DSA. This is an agreement between the DSA and the county on how they will interact with IOLERO. It is not my agreement. It's an agreement between the Deputy Sheriff's Association and the county and how it will work with IOLERO.
You
But
don't have an agreement. You have an operational agreement.
I have an operational agreement with IOLERO and how we will transmit information and things of that nature, but that agreement has nothing to do with the Deputy Sheriff's. It's how I will transmit information between how we will work together as an office. When we have, what reports we'll get, how we will send them over, those sorts of things, but they have nothing to do with the Deputy Sheriff's. I can negotiate, John and I can redo, the Director Alden and I can sit down tomorrow and redo our operational agreement, because it has nothing to do with the Deputy Sheriff's.
Do you support it being a meet and confer issue?
I think it is a big fair
Do
issue.
you support that it should happen?
Do I support that it should happen? I say that it's not my issue. It's an issue between the employees and their ultimate employer.
That's a different question. Do you support as sheriff, based on the community's vote for this ordinance? Do you support that meet and confer should happen?
I think those are two different questions. Do I think meet and confer should happen based on the vote? I think the meet and confer has happened on two different occasions.
But where we're at now,
No, I don't, because I think that there's been two different negotiations based on this ordinance. And fair is fair. They weren't talked to in the beginning. And I'll tell you that Measure P, IOLERO, it has nothing to do with me as sheriff, as a person. Whether they are ordered to talk to IOLERO or not, it does not matter to me at the end of the day. What matters to me, and part of the reason why I do this job, is fairness. Ultimately, that's what it comes down to, is fairness. And the deputies were treated fairly in the beginning. And it's more and more and more. Now, the IOLERO and the county want to sit down with the deputies and renegotiate the entire LOA and give and take. That's between them, but that's not what's trying to happen. It's, we got this, we have this, and we want more. It wasn't fair then, in the beginning, and it's not fair now. I'm for fairness. That's why I do the job that I do. And I understand what the voters voted for. I completely understand it, but the way that it was done was not fair at all. And if there's anyone to blame, there's two people to blame. And there's two people to blame. The Board of Supervisors at the time for not being the grown-ups in the room and telling the people from Clean, we're the adults in the room and this is the appropriate way to do it and we're going to meet and confer. And the people from Clean who browbeat the Board of Supervisors at the time and didn't let them do the right thing. Those are the two people that should be blamed right now for the situation that we're in. But the blame always goes to the deputy sheriffs. Always. They're obstructionists. They're doing legal wrangling. Everyone talks about legal wrangling, but ask yourself this question. If you're accused of a crime and your defense attorney defends you to the best of your ability and you get out, is that legal wrangling or is that your defense attorney doing their job? But when the deputies do it, it's always legal wrangling. Always.
I have a question related to what you explained on the administrative review investigations, which I didn't clearly understand before, and now I have a better understanding, so thank you. So would you ever, or do you know of any sheriff's offices that might conduct an internal affairs investigation separately from the administrative review investigation if there's a casualty, without like requiring, like you said, there wasn't a complaint or anything, so that's why you only did only the administrative review was done, but are there any policies out there that would trigger one being conducted without a complaint having to be filed or anything like that.
I do know that there are sheriff's offices or police departments that do that. There are also sheriff's offices that, so we do things, every agency is different. So there are some agencies, so our deputies give, voluntary statements. Typically, they give voluntary statements in possible shootings. So they voluntarily give their statement to whoever is conducting the investigation. And some agencies, based on advice from their attorney, they never get a voluntary. Possible policy violations identified, policy can still be changed. That happens routinely. In this case, I did not identify, or neither did anyone in the command staff identify places where policy could be changed or should be changed. You have to realize what this situation was. You know, the foot chase for several amount of time and trying to apprehend someone who committed felonies. That's what people expect us to do, apprehend people who commit felonies. I mean, that's the expectation, not only just felonies, but crimes.
Well, transition. Working.
Yeah,
I think that's
got it.
I had one question too. Were you gonna keep?
Yeah, I was
Yeah.
just finished. I mean, it ultimately was a tragic incident all around. And you know, anyone who thinks that anyone in law enforcement comes to work with the intent of utilizing lethal force or hoping to use lethal force, is someone who clearly doesn't know someone who has used lethal force and seen the aftermath, even if the person didn't die. I have. It's something that grabs people with guilt. And sometimes people never come back to work. If I believed that there were policy violations in this case, we would have opened an internal affairs case. It's not, well, it is a badge of honor. I fired more people in the 3 years that I've been sheriff than I can remember anybody firing. Because I hold deputies to a high standard. I issue harsher punishments than any sheriff that I know of since I've been involved in discipline. I was an internal affairs investigator, so I know. I ran the unit as a lieutenant, then I was in the command staff. I hold our people to a high standard, and when I believe that they do something wrong, I hold them to account for that. As I said, this case was tragic. I know people may disagree with the level of force that was used. And reasonable people can disagree.
In any of the reviews, administrative, internal affairs, across the board, is the question ever asked, was the shooting and fatality avoidable? Like, is that a question that gets asked in these processes for you?
I don't know if the question is specifically asked, but that is definitely one of the evaluations that we made. When we're looking at it, I mean, if we believe that something was avoidable, then, that was something that would go down the line of, de-escalation. Did they have to be in that situation? Was that something that they needed to be in? They would probably fall within that category. If it was a tactical training issue, then we would address it as a tactical training issue. In a particular case. So that question is asked in the evaluation of the case, and we had a case recently like that, adaptable. We saw, let's try to think. Last month or so. Anyway, that is something that we typically look at, and then sometimes we look at what occurred and we make a policy change. And we look at everything. We've had a lot of crashes. It's not one, now your first crash, you get a little reprimand. That wasn't the case, but we've had a lot of crashes. So things are always changing, they're dynamic, and but we do evaluate cases and look for what we can do better, and if a policy change or modification would be better.
Sheriff, I feel like, and please correct me if this doesn't sound accurate to you, but I feel as though what you've told this group tonight is something to the effect of, there have been a lot of problems in the past in the, in putting Measure P and putting IOLERO's work into motion. Mistakes have been made. There's maybe even been some disrespect in your view, directed at your office, and others, the deputies and the like. And that as a result of all of that, the stance that I hear you asserting is basically this issue with regard to Liebarger and the ability to compel cooperation with IOLERO's questioning is not your problem, and you don't intend to do anything to try to fix it. Is that fair?
I think that's a very lawyerly way to put it.
Well, then say it your way. Say it your way, because I want to make sure that I have a really clear understanding of the reason that you're saying, well, I'm not gonna do anything
Well, I
to
think,
try to
well, I
fix
think
this.
what I heard from Director Alden is that the county can enter into it. Because here is what I'm saying, is that the letters of agreement are not an agreement between the sheriff's office and the deputy sheriff's association. That's not my agreement. It's like me going and talking to your bank about your loan. It's not my loan. It's not. The letters of agreement are between the county and the deputy sheriff's association and SPLEA. Let me finish. The letters of agreement are between the county and the deputy sheriff's association and SPLEA, and how IOLERO conducts their business and overseeing them as it pertains to Measure B and the subsequent letters of agreement. That's their agreement, not my agreement. And the only way that I am involved is if I knowingly trigger a violation of their labor rights. And I am not going to knowingly trigger a violation of labor rights. So that is the most accurate way to put it, is that I am not going to knowingly trigger a violation of labor rights to fix someone else's issue, because that's what you are asking me to do. That is how I will put it. I will not knowingly trigger a violation of labor rights, because that is what you're being asked me to do.
Well, I think that what you're being asked to do is to work in the direction of the transparency that Measure P.
By
What,
triggering violation of labor rights, because that's what I would have to do. So you can say that that's what I was doing, and you are
you
correct.
just asked me to let you finish,
I'm sorry,
and
go
now,
Sorry, go ahead.
so. You're making an assumption that might be correct, but I don't know that it's correct. That there is no other way that is available to this county to carry out its voters' intent, right? That this operation over here be able to ask questions and the deputies be compelled to answer them. Your statement is an assumption that there's only one path, that's the only path. I'm not convinced of that. I feel like what's going on in this county is that people that have been elected and appointed to serve this county are not working together to get Measure P's intent to make it real, so that the investigations that the voters have asked for can actually occur with the authority required to get questions answered. I feel like people who have been elected and appointed to serve this county are refusing to work together to try to effectuate that goal. That's the only way I can respond to what I'm hearing tonight.
So here's what I'll tell you. The Deputy Sheriff's Association has said they are not going to do committee confer unless they are forced. The only way to force them is for me to trigger a labor violation. Director Alden, what did Anthony Dean tell you about a year and a half ago when we even broached the idea of, on a Zoom call, when we even broached the idea of talking about the letters of agreement?
I don't specifically.
Was it something to the effect of, we're not changing, and if we do, we're coming after you, and then we're coming after the sheriff in court? Was it something to that effect?
I think I remember that, but I want to back up a little bit by saying, I don't see any reason why we'd have to trigger a labor violation to get to meet confer. Like, usually that happens without labor violation by just asking to meet confer. Parties refuse to meet confer, they can go to court to require someone to meet confer, like is what the county did to get DSA to come to the table and confer with Measure P.
But I just said, the deputy said they're not going to. They've said, they are not meeting, they do not want to meet with her, and they're not interested in sitting in front of IOLERO to answer questions, especially after what happened during this case, where an investigator told them that they were protected under live barter, which they were not, and if they didn't answer their question, that they would be subject to disciplinary action, which they were not, because IOLERO cannot discipline deputy sheriffs. So deputy sheriffs sat in an interview after they said they were going to assert their Fifth Amendment. They came anyway because I ordered them, and they were told, number one, their interview was protected under live barter, which it was not. And then they were told that they didn't answer questions, they'd be subject to disciplinary action, which they were not. They were told two things that were not true. So why would they then go and put themselves in that position? They are not interested in meeting and conferring. They've told me that. And I'm not going to trigger anything. I think if Director Alden wants to go and talk to county HR, he is more than, I welcome him to do it. He can do it. He can talk to HR just as quickly as I can. And he said it's not, and he says that they don't need me, and they didn't need me before.
I think you have to agree, Sheriff, that the thing that I asserted is accurate.
I'm not gonna
That,
agree. I'm not gonna agree. That's your assertion, and that's how you wanna paint the words, but that's not true.
that's what I'm hearing.
Well, then you better hear what I said and write it down.
Is getting us
Farther along.
farther along, so let's, let me just say this. First of all, I really appreciate you coming here tonight, I really do. I have heard things that I didn't know before, both historical. I think that there are things also that happened historically that are the county's fault. I think that they got some bad legal representation. IOLERO got some bad legal representation in the negotiations over the letters of agreement. I also know that although the Court of Appeal said that these issues around the independent investigations are not negotiations, but they're meet and confer. They're a different kind of negotiation. They don't, as John said, they don't have to come to an agreement, that this county practically does do it, does treat them all the same. And that's a choice the county has made in terms of its management style. So we have a number of complicating factors in all of this. But we now know that the sheriff is not going to issue any live heartburn admonitions, and we thank you for clarifying that.
Thank you, Sheriff. And I would just add that I think there's also confusion, at least that's how I'm interpreting it, and what you just said about the part that's not negotiable, that is kind of like set.
Yeah, it's not like set, it's that you meet and confer, but you don't. Under the law, you don't have to come to an agreement on certain issues if they're not like wage and hour and contingent.
Yeah, like to me, it kind of sounds like the times we've come to you or you've come to us and said, we have to revise our policy because this new law came in. So if there's parts from Measure P that were determined that they are lawful and should be applied, then I feel like at that point, the DSA has no choice but to say, okay, well, we need to meet to figure out how we put that in place and what we do on a daily basis. And it's not to meet to figure out if they do it or not, it's to meet to talk about how they do it. And I see it as like something different, and I guess maybe that's one of the issues on how that's interpreted. And also, I agree with what was said about the county. I've mentioned that lots of times as well, and I think with IOLERO not having when we had an interim director, that also made things complicated with the negotiations that were going along and the things that Garrett decided to do on behalf of the department when we probably should have waited on. There are a lot of issues, but I feel like this is gonna come up again. And if it has to come from the Board of Supervisors and they're refusing to, that's one thing. And you already told us that you're not gonna initiate it, so I feel like that's our only option. And I don't know if it would help to get an understanding of how they see it, if they just see it as something that's gonna be negotiated, or if they see it as something that has to be put in place and they just talk about how to do that. And they could trigger the meet and confer process that way, because it's not, I feel like it's about something different. It's not about the same thing that they already met and conferred on twice.
So. Two things, the deputies do not want to meet and confer on this, because if they enter into meet and confer, if there is no agreement, ultimately the county can impose on them what they want. And that is why they do not want to intervene and confer. Because if they're,
Ultimately, the county.
the county can impose on them what they want. So that is why the deputies do not want to enter into confer, because once you enter into confer, is, you know, Director Alden is correct, it's not necessarily negotiation, even though the county does treat it that way. At the end of the day, after they've met for so much time, they can be imposed on, and they have no say in whatever happens. So that's why they don't want to enter into confer. I would say the county doesn't want to enter into meet and confer, which I heard that pretty clear at the annual report. Why that is, I would suspect that two things is that they know the Deputy Sheriff's Association will take them back to PERB for unfair labor practices for trying to negotiate an agreement 3 times within a very short period of time. When they had the opportunity, they had 2 bites at the apple, and they did not see this issue. Would they be successful? I don't know. And there may also be a feeling among some that how this originated was wrong, and they mistreated an employee group, and they never would have done that to any other employee group. And hadn't it been the summer of George Floyd, they certainly would have done it, but they did. And so this is, in my opinion, their mea culpa. That we're gonna let things stand as they are, and this is what it is, and, you know, every few years, the sheriff and the IOLERO director will end up in the newspaper arguing about this, and things go on.
I feel like it
That's
just-
just my feeling.
Yeah, just makes things complicated for IOLERO, and then for you also to have to address this, and then we also want to make sure that we have a good relationship as an oversight agency and as an enforcement agency, and then us as the individuals appointed to kind of be in the middle and understand how each party works. And we have elected officials and other things that we don't know that get discussed, and it just gets complicated to understand how we can resolve such an issue when it might be something as simple as saying, this is gonna be put into place and we need to initiate the meet and confer process. So I don't know if it's something that maybe the CAC needs to discuss as pressuring the Board of Supervisors and getting a response directly from them or what, but I think that would be a conversation for a different meeting. And aside from that, I feel like we touched on a lot of points. We covered a lot of things outside of this resolution. I think we get your perspective really well, and oh, we haven't had public comment on this item, so, and it's not a Q&A thing. We're gonna open up for public comment, and because it's already 7:23 and we have another business item, we'll do 2 minutes for anyone who's I don't see hands raised at this time, but if there's also anyone in the room who wants to provide comment, do so now. And then we will close out this item and continue with the rest of the agenda. Is there any public comment? So we'll do 2 minutes.
My name is Steve Hydell. I live in Santa Rosa. And it's relevant to this is that I've participated in neighborhood watch and do a lot of de-escalation personally. And I'm just want to encourage the sheriff's department to put a lot more effort into that kind of training. Because I know from personal experience that it's not easy. It can't really be planned. And it does work and it can be very effective, but I don't know the exact details of this particular issue, but it sounds to me like there was confrontation and then it got worse, and then somebody got shot. When maybe that didn't have to happen. And I'm just want to say that de-escalation is like a complex social process, and there's a lot of techniques to it. And if someone gets emotional in a confrontation and gets a little angry or upset or fearful, then they could make mistakes and people could get hurt. So just I guess. This whole thing might not have happened if the officers, even with all the things that happened, they were still trying to think about how can I de-escalate and arrest this guy without anybody getting hurt. I know you do training, but I'm just saying even more and in a greater interactive kind of process that would be more effective.
Thank you. Any other comments? Okay, there's one hand raised online. Oh.
Yeah.
Yeah, Megan Gordon. Go ahead, Megan, you have 2 minutes.
Hey, I'm sorry, the system glitched out on me a little bit. Is that my turn to talk?
Yes.
Okay, thanks. Well, I know there are a lot of people that usually go to the CAC meetings that aren't there tonight because of other things, myself included. And I'm not a lawyer, but just hearing the word policy violation a million times is just so sad. I mean, we're talking about some really serious issues. The sheriffs are the people that have guns, the sheriffs and the police. And it'd be nice if somebody seemed like they cared more. It'd be nice if Sheriff Ingram seemed like he cared more about the people that died. You know, David Ward was killed by Officer Blount, who had a long history of brutality that could have been dealt with. And fairness. Everybody wants fairness, but we also just want to stay alive. Let's see, I appreciate everybody talking and being calm and pursuing change. I mean, policy, yard counseling was policy. Was that a good policy? No, it was not a good policy. So having a group of deputies surround people for being mouthy and then inflicting pain on them, that was policy. It had a name, and now it is no longer policy. So maybe we could do better. You know, let's change some policies. Let's care about people. Let's de-escalate, like that other guy said. I think it'd be better for the deputies too. I know they don't want to go out and hurt people. I work in mental health. I do a lot of de-escalation. I'm only allowed to place hands on people if they are a danger to themselves or others. And, you know, it's just very sad that this is happening. And David Playa Chavez did not need to die. And we should be sorry that it happened and not talking about policy. We should be changing things. And that's what IOLERO is for. So thanks for letting me say something about it. And thanks for the work you do. Bye.
Right on time. Thank you for your comment. Okay, seeing no other hands raised and no other public comment in the room, we'll close out public comment. Any other thoughts or, yeah, or comments from the CAC, but she's not the public, she's CAC. Go ahead, Robin. Final.
Well, I just have to say, I'm leaving this meeting with a sense of real discouragement. Because I feel like we've, you know, shown that a lot of mistakes were made in the processing of this, you know, the interpretation and the whole process of getting IOLERO set up. And I feel like, I just don't understand how we can say that the sheriff just will not deal with it, and the DSA probably will not deal with it. They'll just refuse to do that. And this board of supervisors will probably say they will not deal with it, when we can say with hindsight that a lot of mistakes were made. And maybe it's time to go back and correct some of those mistakes. And I hear that there is, you know, at least a willingness on the part of IOLERO to go back and, I guess, meet and confer. And I understand that there's these issues of human resources and stuff, but those can all be dealt with. They can all be negotiated or met and conferred over. I just feel like as a voter in Sonoma County, it is very discouraging for me to hear this is a done deal. We've already tried to do this twice. It didn't work. The people were wrong. The board of supervisors are wrong. And now it's you know, now it's just set in stone and we're not gonna change it. I feel like that is not, responsive to the voters of Sonoma County. And I find that highly discouraging personally and on this council.
I was just gonna say, I mean, there's been so much talk about all the legal issues around unions and bargaining and all this stuff, that part of me would love to have like a third party labor lawyer expert come in and actually talk to us, because we're getting a lot of, opinions from people that have skin in the game, right? So I'd love to get like an objective analysis of this whole thing, because I feel like it's very confusing as a non-lawyer and a citizen and a taxpayer. And everyone keeps making their arguments, but I would just like to get the honest truth from a single source that is not involved in any negotiations going forward and is kind of third party. So,
Well, Nathan, I would disagree with you. I have no skin in this game, which is what I keep telling you. I'm not a party to Measure B. I mean, I didn't negotiate it. I'm the sheriff that's gonna live with it. And all of these things happened before I became sheriff. Measure P was voted on before I became sheriff. The letters of agreement, first and second, were negotiated before I was sheriff. And all I have to do is be the person to answer for what was done before me. And the only answer that I have is myself engaging in something that, getting involved in something that has nothing to, I have no skin in the game. Interview deputies, don't interview deputies. I didn't have any part of this agreement.
I was more talking about DSA attorneys and everyone else, but I mean, I think you do have skin in the game, because obviously the DSA people report to you, right? So they're in your organization, so of course you're involved, right? That's why you're sitting here, and
They have
that's
to
why we're
report-
talking.
They have to report to me regardless.
Right.
The only reason I'm here is because I think that this council mischaracterized what I did leading the office as it pertains to this case. As I said, if this council was doing a resolution based on something that I believe I did, then I would be okay with that. I live or die by my decisions. And the reason I'm here is because I believe as I said, that what was being said in the resolution mischaracterized my actions. I did not legally believe I could give them live arbiter admissions, and the legal counsel that I had, that's what was told to me. That's what the case law says. We may disagree with what Sheriff Luna did versus what I did, but the fact remains the same. When he made that order, it went to court. If I make that order, it will go to court, because that's what the DSA said it would. And I don't understand why an agreement that was made, not just without me, but without any other sheriff's involvement, has to result in me going to court.
Understandable. I think we've- yeah.
Well, I'm gonna say, if that is the only path to the transparency that we're all here to drive forward, then maybe that's the only path. Transparency is what we're here for. It's certainly one of the very few things that we're here for, and that you say that you support. And so, yeah, I think that this group just asks you to do your best to drive transparency forward, rather than saying some version of somebody else screwed up, it's not my problem.
Well, what I've always said from the moment I ran, and what I always say now, and some people disagree, is that Measure B was a flawed ballot measure put on the board, put on the ballot illegally. That's what's been ruled on, and that's why we are where we are. I support transparency if it is done in a fair manner, and I will support, and I would adhere to everything within Measure B and the letters of agreement that are deemed to be illegal. What I will not do is something that is illegal in the sake of transparency. I won't.
Thank you, Sheriff. Well, we really appreciate you coming tonight to address the CAC and the public, and we thank you for your time. I think we've all gotten a lot of information, and it gets more complicated, I think, but we appreciate you coming, and again, like I said in the beginning, you're more than welcome to come and talk to the CAC about anything that you see on the agenda where you'd like us to hear your perspective directly from you. You don't need an invitation. You can always join us if you're happy to and if your time allows it. Thank you so much.
Thanks, Sheriff.
Thank you.
Thank you so much for coming.
Should we take a little break?
Thank you.
Yeah, let's take a little break. 7:35. Let's come back at 7:40.
Thank you.
Who's amendment? 7:40, and before we move on, so we are going to continue with the agenda, but we're going to skip items 6A, the business item. Number 7, number 8 and 9. Number 12 and 14. And those will be continued to the next regular meeting. And we will keep the rest of the items on, so. That means we're at number 3, approval of the October 8th meeting minutes. Are there any comments from CAC members? Okay, is there any public comment on the minutes? Okay, we'll close out public comment, seeing none. Is there a motion to approve the minutes?
Move to approve.
Okay, we'll do with me and Robin in second. All in favor, say aye. Aye. Any nays, any abstentions? Okay, thank you. The motion carries. Item number 4, we still have a vacancy in District 2. Number 5, oral reports and comments. We'll start with the sheriff's liaison reports and Lieutenant Kidder and Don, if you guys can keep your reports short and brief, that would be great, please. Go ahead.
So I won't go through every community engagement event. There were a handful over the last month. Again, community engagements at schools, first responders, resiliency gala. There was a fall fun festival at the Valley substation. With games and treats geared towards families, just to get the, just to really engage with the community. Had a meeting earlier today with the ad hoc committee on community engagement regarding ICE. If I said that correct? I'm not gonna talk much about it. I'll let them talk about it because they're in their report. But shoot, I think we talked for like an hour and a half.
Yeah, it was a long meeting.
Following up on one of the questions or comments from last month was that ICE warrant that I spoke about. The question was it a judicial warrant or an administrative warrant? I think was the word. I confirmed it was a judicial warrant. Regarding statistics for the month of October, there were 54 notifications received from ICE, and those again are notifications of release. There were 7 notifications returned about impending releases. And there were 24 requests for information. And then the last thing that I think I'll say, and I'll keep this as short as I possibly can, is I know previously I had reported about our website not being great. And that project is kind of on hold because of budgetary reasons. It is actually moving forward. I learned today at a manager's meeting that we had at the office. The end of this week, there are 2 more vendors that I guess we're like interviewing, which will narrow it down to 3. After that, we'll pick one. And then they're gonna move forward updating the website. So no timeline, no proposed end date. However, the project is still moving forward, and I know our website has been an issue for some, so that is in the works to hopefully improve and be better.
Thank you.
That's all I got.
Thank you.
I'll be really brief. Most of IOLERO went to the NACOL annual conference in Minneapolis since we met last, and some CAC members I know got to go as well. We also had, since we saw you last, the annual report from IOLERO was at the Board of Supervisors. That was October 21st, 2025. So for people who want to see our presentation there, which was obviously much longer than the presentation I made tonight, you can find that at the Board of Supervisors website. We will have a virtual town hall next week on Monday, November 17th at 6 o'clock, which you can get to through our website, where we'll answer questions from the public about the annual report, at least to the extent we can. Some things we can't answer, but if anything that's publicly available, we're happy to answer. So we offer that in part because this meeting that we're at tonight, and also the Board of Supervisors meeting from October 21st, are meetings that are subject to the Brown Act, which makes it difficult to do question and answer. And so we want to make sure there's an opportunity to future questions. And we'll go over some of the same material covered at the previous Board of Supervisors presentations. That will just have a little bit more of an open format for people to generally make inquiries. We did have on the agenda tonight here at the CAC a presentation about that annual report, but I understand that's been tabled because we've got a long night already. So I think this year we'll probably forego that, say everyone can see the town hall. So
if that will be recorded and available on the website.
Yes, it will be. And in addition, our annual report is now up on our website, so you can read the hard copy there. Right now it's in English, the Spanish version is coming, so that'll be available soon. I think it's just being approved by ISD, if I recall.
Remediated.
Yes, remediated, right? And so that's ready to go up, and everything else can go next time.
Okay, thank you. If it's okay, can Lizette send out the link to the Board of Supervisors meeting so that everybody can watch the discussion and get caught up on that, since we are skipping item 7, and then also the link to where the annual report lives on the website. Because I think similar to the sheriff's office, I think the county's website is also kind of hard to navigate. Yeah, those two links that take us directly to the meeting recording and then to the actual annual.
Can I suggest she also sends out the link for the virtual presentation that's happening on Monday?
Oh, yeah,
That
and
would
the
be
town
good
hall.
too. I mean, it's in the newsletter, but it would be good
Yeah.
to just have us all get it.
Thank you, Lizette. And then public correspondence report, there's nothing for us to report. We did receive public correspondence and it was shared with all of the CAC. And I think that's a good practice, that if we receive public comments, that it goes to everyone. So we're not just narrowing it down to just Nancy and I. Okay, so now, are there any questions from CAC members on the reports? No, any public comment? Okay, seeing none, thank you for those. Moving on to item 10. CAC committee reports, and we'll start with community engagement. And there should just be a quick report out.
Yeah, and the only thing I want to mention is that there's that has been working with perhaps doing listening sessions, and we're gonna talk about that more. That will hopefully happen sooner rather than later, and that's all for that.
Racial and identity profiling, Ash.
We're done. So I think that's the basic report. You sent the letter back to, the river board, and I think we CC'd everyone we were talking about CCing on that letter, and that was kind of our last action. So that one's basically done, and,
Yeah, the only other thing, we did check in with Sheriff Ingram on having a policy specific to RIPA, and he did say he was working on that.
Yep.
And so we'll just follow up with him as something that, we'll just keep track of, but aside from that, and the goals that we established, we've gone through all of them. Not yet. Policy recommendations review, K9.
But we haven't done anything additional since the CAC adopted the recommendations and they were sent to the sheriff. So, and I don't anticipate that we're going to
Were there any other goals that were established at the strategic planning session last year that are pending? Okay, so then that would be another ad hoc that's basically done. Okay. Community engagement about ICE.
All right, so, we met today, had a fruitful discussion, I think, with Michelle and Yasmin and Tenny Kidder. There's a lot of information we went over. They're going to be sending us, blank copies of the forms they often refer to in terms of like the notification requests that they get from ICE and what they use to respond to ICE, as well as, the, it's a sort of an appeal that inmates can, have the right to appeal after they're notified that ICE has requested notification and there's notification and they can appeal. So it was a fruitful discussion. I think they clarified, kind of the flow of information that, ICE request, how ICE requests come through, et cetera, and how ICE is notified. And we went through the statistics up through September, because that's what we had. I think they were working on October, or they have the October numbers, but we were based off the September numbers. There will be more information to come. It was a long meeting. There was a lot of information presented. But we probably, one of the things that came out from there was that even for us as CAC members, it was helpful to learn the flow of how the requests come down and how that all works. And so we were discussing the possibility of even having like a flow chart for our members to understand and then differentiate between the notifications. I know we've had questions about notification requests and requests for information, and how those differ, because that was clarified slightly better at this meeting. Michelle was very open to having discussions. She was very, very nice, and I think Kidder jumped in there with some questions because he knows we ask him the same questions over and over again, so we wanted to make sure we didn't ask them again. But yeah, I think as has been the case with the sheriff and his staff on immigration, they've been more open and willing to meet with us. Like I said, today it ended up being about an hour and a half meeting, with a discussion on immigration. So more to come once we get the forms that she's gonna send to us, so that we can, you know, they're often referring to them, so it'd be nice for everybody to see what those forms look like and what's being asked for. So she committed to sending us forms that possibly was. Add anything else, Nancy?
The only other thing is that we had sent a draft flyer that we would want IOLERO to be distributing, with resources on one side and sort of what the sheriff does and doesn't do on the other side, and they approved was one change, which we will make, and then that will be available when we do tabling and that kind of thing.
Yeah, and do you wanna add why, because Lieutenant Kidder brings those flyers at every meeting, but why it was discussed that IOLERO or the CC would have their own?
We wanted it to come from somebody other than the sheriff. You know, there's been a history, you know, sort of a bad history, prior to our current sheriff, the relationships, and we wanted something with a different, not the sheriff's star on it, to pass out. We think that that might help with the public reception of the information. And we did spend a lot of time talking about the difficulty of trying to correct misinformation.
Thank you. Okay, moving on to open time for public comment. And this is for items that are not on the agenda, and we'll do 2 minutes. Maybe a minute and 30 seconds. Okay. One, okay, we do have one.
Okay. Good.
Well, since we just have one, well, we can do 2 minutes. Sorry.
Okay.
You can go ahead.
Okay, start.
Okay, thank you, Gig Hideout, Santa Rosa, and, so, given the story that we heard here tonight, I don't know the extent of how these things go, but wouldn't it have been better if the deputies really were highly skilled in de-escalation and didn't kill that guy? I mean, that's to me like that would change everything about this, everything. So, you know, everybody does they say they do de-escalation and so on, but I know from personal experience that when you're in a situation, all of a sudden there's nervousness and tension. Nobody's thinking about, let's see, lesson 4, I'm supposed to do this. It's all automatic. And, when I do it, which is often, because I deal with homeless people who are coming into our neighborhood, and so when I go out and I hear, okay, so there's this guy who's a transient, he's got all this stuff, he's behind this tree. So I go out to talk to them. Before I do, I say to myself, just pretend this guy is your cousin, okay? So I go and I'm trying to be more of the social worker than the cop, and I'm trying to be passionate and concerned. And they get that. And then we talk about, oh, you know, you can't camp out here and you can't do this, and you know, you need any help, whatever. And so then that's the end of it. And they just decide on their own, you know what, I think I'll keep going. And so that resolves the problem for our part. And everybody's fine and nothing happens. But partly because, I mean, sometimes I get cursed at, sometimes I've been assaulted. But I've been always able to actually physically de-escalate the assault so that I don't get hit, and I don't have to hit them. And it just works, but it's not something you can just, you know, have in a lesson or read in a book. It's a really deep thing. And I was wondering, okay, let me just wrap up. Given what you've experienced, can you make a recommendation that the county or the sheriff's department do something to really up the game on de-escalation training, experiential training?
Thank you for your comment. Okay, we'll close out public comment and then go to item 13, CAC announcements. Any announcements for CAC members? Okay, seeing none, then we are at 7:57. This meeting is adjourned. Our next meeting will be on December 10th, and that is a Wednesday here in this room at 6 p.m. And we will be discussing how we plan on handling the strategic planning session or the retreat in January. And then don't forget about the virtual town hall for the annual report. Thank you all for being here tonight.
Thank you, Loretta.